What would happen if you found me parked right there? You get a ticket. So how do we give you a ticket? What's your name and badge number?
A citizen sees something I'm sure we all have throughout our days when we are in public, an officer parked illegally.
Officer S-Cobb, 5970.
All right, but you're not above the law, brother. Okay, so you're gonna get a complaint. You're not gonna get a ticket, you're gonna get a complaint.
Okay.
All right.
City allows us to park here.
No, not that sign. It says from here to corner. Why you allowed? Trust you? Why? Because you're a cop?
So he starts up a conversation. Officer Eskove, sensing the more he speaks on camera, the worse the exchange will go, decides to get in his car.
Have a nice day.
Why? Because you're a cop? Hey, you're not above the law, man. You know what I'm saying?
See, that's what they do. They ignore you because they know they're wrong.
Hey, just remember, you're not above the law.
Which, let's be fair, is true. They're not supposed to be above the law, but in reality, because of the systems in place, they are. With lack of oversight and, of course, punishment. Thank you to the YouTube channel Behind the Scenes for their piece. But let's get back to this. Are cops above the law? Noah Feldman brings this perspective. The doctrine of qualified immunity muddles the principle of equal justice under law, nor is qualified immunity contained in the text of any federal statute. It was invented by the Supreme Court in a series of cases, most importantly the 82 decision of Harlow v. Fitzgerald. Essentially, qualified immunity says that you can only win a suit under Section 1983 if you can prove that the official's conduct violated clearly established federal law. To prove that, you generally need a judicial precedent describing their specific conduct as unlawful. As the Supreme Court itself has said, the doctrine protects all but the plainly incompetent or those who knowingly violate the law. The ACLU piggybacks off qualified immunity for police, writing, the Supreme Court recently held that in cases with particularly egregious facts, plaintiffs could win cases without having to rely on a previous case about the exact same conduct. In doing so, the Supreme Court overturned a Fifth Circuit decision that granted qualified immunity to corrections officers who held 2 incarcerated people in inhumane conditions for 6 days. 3 months later, the court sent back yet another Fifth Circuit decision under similarly deplorable grounds, pepper spraying an incarcerated person for no reason at all. By doing away with qualified immunity, we can begin to hold officers accountable for their conduct while reimagining their role in our communities. However, that's only a temporary solution. The real fix is to get police out of the business of responding to mental health crises entirely. The lives of people with disabilities are at stake. Police are 16 times more likely to kill someone with an untreated mental health disability compared to someone without a disability, and people with disabilities represent between 1/3 to half of all people killed by police. At least 1 out of every 4 people killed by a cop in the last 6 years was experiencing a psychological crisis. Michael J. Steinberg, a professor from practice and director of the Civil Rights Litigation Initiative at the University of Michigan Law School, wrote, there are at least 3 major reasons that qualified immunity should be abolished. First, when a police officer or other government official violates the rights of Americans, the victims of government abuse should be compensated for their injuries. Second, unless the government official who violates constitutional rights is liable, there is no accountability. Third, if government officials know that they will be liable for violating the civil rights of the citizenry, they will be less likely to violate the Constitution. Without consequences, there is no deterrence.